Adjustment. Item number 1.
Consequently, the petition stands allowed. Accordingly, the impugned CR case number 1 of 2018, along with the orders dated 12/4/19 and 21/5/19, passed therein taking cognizance of the offences mentioned against the petitioners, shall set aside and cost no costs.
Much obliged, Your Honor.
I have not signed all the papers, so you keep it now.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 6, Lordship. This is a contempt matter and the order has been complied. And in fact, the respondent number 5 has filed a compliance report as well. So, Lordship may close this matter.
Your name is not here in the list.
Item number 6.
Your name is not here in the list.
Sankam.
Huh?
L. Sankam.
Okay. Mr. Swensu, appearing for the petitioners. Also heard Swensu appearing for respondent number 5.
Respondent number 5. And respondent number 3, LT Sankam.
Respondent number 3 and respondent number 5. It is submitted by the learned counsel for the petitioner.
And respondent number 2 by Enangami. He's on like in court number 1.
It is submitted by the learned counsel for the petitioner that the order
dated 7.
Order dated
4.
passed in WPC number so and so
Yeah,
has been complied with, and therefore the contempt petition may be closed. The respondent number 5 has also filed an compliance report. In view of the above, contempt petition stands closed. Yes.
Yes, sir. Mention item number 20.
20.
Yes. Bishop, I'm waiting for one instruction regarding the policy of two-line road construction. So the matter will be allowed to list this next week.
Who's appearing for the petitioner? Have you informed?
Yes, I have already taken the counsel of the.
With the consent of the counsel for the petitioner, the counsel for the respondents pray for listing of this matter after?
Next week.
In the next week, as he is awaiting instructions.
Your Lordship, I'm for the state respondent number 3 to 10.
For the state respondent number 3 to 10. Accordingly, list the matter. Sorry? Respondent number 2. Accordingly, list this matter in the next week. Yes.
Please, Your Lordship, I beg to mention hearing item 24.
24.
Yes, Your Lordship.
Okay.
Lordship, kindly this matter be listed after 2 weeks. Since my senior is in this post.
You are appearing for the petitioners?
Respondent number 3.
You are appearing for the respondent. Have you informed the other side?
Yes.
Your name?
Rebecca.
The counsel appearing for the respondent number 3. Prays for an adjournment for 2 weeks. 2 weeks. And states that the other side has been informed and does not have any objection. Accordingly, list the matter after 2 weeks. Yes. You are for the other side. It's the petition. Anything? Yes. Yes, madam.
Yes, Your Lordship. Lordship, I beg to mention item number 5.
5.
Yes, Your Lordship. The conducting counsel is out of station.
You are for the petitioner.
Yes, Your Lordship.
Your Lordship, I'm appealing for the respondent marriage in this
Do you
matter.
have any objection?
No marriage.
On the prayer of both the parties, list this matter after
4 weeks, Your Lordship.
4 weeks. Okay. Yes.
Lordship, I'm for the respondent.
Much of them grateful marriage.
Any more? Yes.
Please, Your Lordship, I'd like to mention item number 18.
18.
Yes, Your Lordship. My senior is out of station due to a family medical emergency. So, Your Lordship, if the matter may come up on 9 September,
You are for?
the petitioner.
You are appearing in the matter?
For private respondent 4.
You are appearing for petitioner.
Yes, Your Lordship.
Miss so and so appearing for
Mr. Izimomi,
Azimomi. Prays for an accommodation of
fixed date for 9
prays
September.
for the matter to be listed on the 9th of September. As the leading counsel is indisposed today, so and so and so and so have appeared for the respondent number 4
R5, respondent
and
5.
5 who do not object to the prayer. Accordingly list the
Your
matter on
Lordship,
the
this is an interim in the matter.
accordingly list the matter on 9th of September. Interim orders if any to continue.
Your Lordship, I have a similar prayer for item 23 and 25 as well,
23
and 25.
and 25. Anybody appearing in 23 and 25 for the respondents? Please mark their presence. You are in item number 20? 24 for the state. Kindly give your presence to the 23 and 25 is what you mentioned, yes. You make the same order, listed on 99. Any interim in there also?
No, Your Lordship.
Yes. Yes, sir.
May I please, my lord? Lordship, I beg to mention item 13,
1313.
13, my lord.
Okay.
Lordship, in this matter, I'm appearing for respondent number 1 and additional AG V. Shokri is appearing for respondent number 3 and 10. Lordship, some time may kindly be granted to us to receive the necessary.
It's a matter of 2023 and a contempt.
Yes, Your Lordship. In fact, Your Lordship, I have been informed by the learned additional AG is that the case of the petitioners are placed before the Treasury for pre-audit.
No, it's a fixed matter. I think that is what the last instructions were. Can we wait till the matter is called for? I'll have to go through the file and then we'll accommodate you. No issues, but let me go through what I had
Lordship,
given on the last occasion.
Lordship, oblige.
Yes. Any more?
Yes, sir.
Yes.
Lordship, I beg to mention item number 17, Your Lordship, on behalf of Sayan Juba, the leading counsel for the appellant.
Yes.
Your Lordship, the leading counsel is indisposed today, Your Lordship, so this matter can come up on 8th of September.
Other side has been
Yes,
informed?
Lordship, consensus prayer.
Okay, on a prayer made of Mr. Tayan Chuba, a counsel for the petitioner,
Appellant.
for the appellant, and not objected to by the counsel for the respondents, list this matter on
8th of September.
8th of September 2025.
Much obliged, Lordship.
Okay.
Lordship, I have similar prayer for item number 21 also. Same party, Your Lordship.
Okay,
Yes.
same order.
Obliged, Lord. Your Lordship, I can beg to mention item number 19, Your Lordship, on behalf of the leading counsel for the appellant, Imna Senla, Your Lordship.
Almost the whole list is being mentioned.
Lordship, she's on bereavement, Your Lordship.
Oh, I'm so sorry.
So if this meeting come up after 2 or 3 weeks, Lordship. If it can come up on 8 September, Lordship.
It is submitted that the leading counsel is in bereavement and therefore an accommodation is sought for, which is not objected to by the counsel for the respondents. List this matter on 8th of September. 8th of September 2025.
Much obliged, Lordship.
Item number 2.
Yes, sir.
Lordship, presently this money suit is pending before the Civil Judge Senior Division, Dimapur. And the respondent in this petition has filed this money suit allegedly under order 37 against this petition. The petitioner thereafter filed an application on 13/6/23 in the case, which was registered as interlocutory application 109 of 2018.
Yes.
Claiming for dismissal of the money suit
Yes.
on the ground of limitation. Since the alleged loan was availed in the year 2012. The petition is annexed at page 45 as Annex 3, Your Lords. Can we see the petition or petitioner?
Yes.
As per provision of section 3, the Limitation Act, every suit or appeal must be filed within the period of limitation. Respondent suit, that is the plaintiff, filed for realization of money from the defendant. Then number 3, limitation period under Article 19 and 21 of the Limitation Act, the recovery of money lent to the defendant by the plaintiff is 3 years. It appears from the Adjournment.
Where is the impugned order? So let us come to the impugned order first.
Impugned order is at page.
And tell me why you are aggrieved with that order.
Page 69.
60 onwards.
At page 69, Your Lordship. Learned counsel, Limatus is present for the plaintiff. Konya is present in person today and has produced the original documents annexed. Learned counsel, Advocate Monarch is present for the defendant. Leptin is present in person. Prayed for leave to defend the suit. The instant case is filed as a summary suit under Order 37 CPC. Seeing that by order dated 29/8/23, passed by my learned PDCCN office, I, so and so, the defendant's prayer for dismissal of the suit.
Can we come to this portion? Can you come to
Pardon?
page 66? Page 66. Page 66. In the case in hand, the last paragraph.
It is seen that the summary suit registered as money suit has been admitted and registered as so and so on 18/7 after hearing plaintiff and by order dated 27/7/20. Fix 8 for appearance of a defendant. However, on the site did none appear and on the 10/8/22 defendant petition appeared in person and learned counsel for the plaintiff appeared. It is seen that on the same date summon for judgment that is served to the defendant, which the defendant also acknowledged that the matter had been fixed on 22/8 for appearance of the parties and also for passing. Thus, on the same date only, learned counsel for the plaintiff appeared and sought for time as negotiation for settlement is underway between the parties, which was allowed. The matter was being fixed on 23/8/20. On 22/8, defendant appeared along with counsel here, filed his vocalogram and which was acknowledged. Learned counsel for the plaintiff part has also appeared. The said defendant admit to his liability for the case of bearing the interest is the learned counsel for the plaintiff.
Now, sir, tell me one thing. As I have understood the CPC, to my understanding,
This happening is after the case was admitted. Now, how the case must be admitted? There is a procedure, limitation act. The court cannot bypass the limitation act, Lordship. Loan is of 12 for 1 year, 13, from December 13 to 16. That is the period for filing the money suit.
thereafter you have, from what I had understood, you had also gone into other agreements.
No, agreements, Lordship, kindly see page 30 and 31.
No, what I am trying to say is,
30
what I am trying to say is any or all grounds that you have to defend your client, there should be a prayer for leave to defend.
Yes.
On your appearance,
Yes.
you did not move any such application.
No, that was a wrong advice by the earlier advocate.
Can that be a ground?
So again,
Is that a ground taken in this revision?
yes,
That there was a wrong advice from the earlier advice?
Yes, that
Where
was-
is the sentence? Where is that it was on wrong advice? And if you are alleging something on that, advocate, then where is the sentence?
you've stated that
Where?
the earlier advocate.
Tell me the paragraph. Tell me the paragraph, sir. I don't find such a ground. That is what. I don't find that sentence. Anyway, we'll not. We'll issue notice at this stage. You take your steps. There is no interim.
Lordship, our
See, the first thing that I asked you is, did you take that leave to defend when you first appeared? You did not. Then you underwent an entire process of mediation. You underwent an entire process of mediation, right? Thereafter, you agreed that you will pay it on such and such date, you will pay the interest, you will do this, you have already admitted the amount, sir.
no, that is how the case first, the trial court should look into the point, law point, that whether the case
So
is filed within that.
all those things will
That
come
is
up
the
after once.
That is
Once.
the vital point, your lordship.
Limitation is, so far as I understand, limitation is a defense for you. Limitation will be a defense for you. If you go by the order 37, the moment the court gets it, they will ask you to come and appear. They will ask you to come and appear.
Then
The
lordship-
first opportunity you have is to pray for defense that, look, it is beyond limitation. It is beyond this. I have made a part payment. Whatever grounds you have, you will place it before the court. The court may allow you that leave to defend. Then you defend it on the ground of the limitation. That will be the first issue taken up. It's a preliminary issue, it will be taken up first. You never asked for that leave. You never sought for that leave.
Then your lordship kindly have a look at document page 30.
Page
Very important, page 30 and
30.
30 and 31. And
Yes.
1 and 2.
Yes.
Whether that
No,
is
all these things will come into play once you have an opportunity of defending yourself in a proceeding under Order 37.
how the
That is to be taken on the first date.
how the trial court overlook this document, your lordship. This is the base of the case.
That is the whole issue.
Page 30 and 31.
Any and all defense that you had to say that this is not an agreement,
Yes.
this is a wrong agreement, I cannot be bound by law. I'll tell you, the point number 1 talks of mortgage and does not describe the property. I can give you so many grounds, but these are all grounds of defense and you must have leave to defend. This is not a regular suit, summary procedure. So before you take that
That
ground, before you prolong the process,
that procedure is also misused from the
that was your first, that was the first stance you had to take. On the first day, let us have the first order.
Honorable court
I'm
can
just-
also see at this stage. Your
I'm just
lordship can
telling
also-
you, let us have Page 37 is the first order?
No, 30.
No, the order. The first order passed by the court, issuing notice, where is it? Issuing summons, where is it? See, 23/8/2022, page 37.
Yes.
Also present the defendant along with so-and-so. I have gone through the application so-and-so. Learned counsel for the defendant submits that this court, before this court, that the defendant admits his liabilities. Are you not in a
That
jam?
is after 10 years.
All these grounds you have to take a leave to defend. How do I go beyond the law?
Even we were
If you had prayed for leave to defend on the ground that this suit is barred by limitation, whether I admit it or not. If the leave had been refused to you, we could have interfered. You stand up there, you say that we admit the amount. Yes, I will like to pay the amount. I cannot pay so big an amount. Please break it up into little pieces. Now can you come back to pray for an interim that, sir, stop the suit? That will not be there. So what we can do is we can issue a notice. Take your steps, let the respondents appear. We'll decide finally. We'll give you a short date. When is the next date?
on Wednesday, day before tomorrow.
Day after tomorrow.
After tomorrow, sir.
And it is fixed for?
It's for necessary order.
It is, the original documents are yet to be marked, exhibited, eh?
Yes, sir. Because the plaintiff remained absent for
Absent on that day.
1.5 years. From 5/10/23. 5/10/23 till 10/6. On 10/6 he appeared.
But he appeared.
Yes, on that day.
Okay, heard Mr.
M. Kolita.
M. Kolita.
M.
M for Madras. M. Kolita. Learned counsel appearing for the petitioners. One petitioner, learned counsel appearing for the petitioner. This civil division petition is filed against the order dated 10/6/2025, passed in money suit number 9 of 2022, and also the order dated 29/8/2023, passed in I number 109 of 2023, arising out of money suit number 92 of 2022, passed by the learned civil judge, senior division, Dimapur, Nagaland. Full stop. It is submitted that the application filed by the petitioner herein defendant in the suit under section 3 and section 18 of the Limitation Act 1963, read will article 19 and 21 of the said act, praying for dismissal of the money suit, was rejected on the ground that on appearance of the petitioner herein, defendant in the suit, he did not agitate his, he did not make any prayer for leave to defend. Next, issue notice, returnable in 4 weeks.
4 weeks.
4 weeks. Counsel, steps to be taken by registered AD within a period of 1 week. The prayer for interim will be considered on the next returnable date.
Our names should be reflected in the, there should be direction to the registry.
It is submitted that the name of the engaged counsel, namely Mr. M. Kalita, is not reflected in the cause list. Registry to verify the wakalatnama and reflect his name accordingly. That will do.
Much obliged.
You want a fixed date? No. 4 weeks?
Item number
Yes, sir.
3 and 4.
3 and 4.
I'm sorry, my lord, I could not be personally present in the court. I wish to be present in the court, but I have some personal difficulties. That's why I am on the online, my lord.
That is okay. That is
And my lord, I'm extremely sorry. The matter was listed on 11/8, but there was a family bereavement, so I could not be attended. Your lordship was gracious enough to allow me time, and my learned friend also, Mr.
Lord,
Zohar, is online. He's for the ED, my lord, my learned friend.
I beg to appear for the Enforcement Directorate, my lord. On
Yeah.
the last date, my learned colleague, senior colleague, had some personal difficulties, so we did not object, my lord. And there's an interim order operating against us in 3 and 4. So, my lord, I would be requesting, my lord, any earliest possible occasion for a final hearing. If today,
No,
Mr. Das-
absolutely no problem. No, this is one request is being made. Kindly see the order of 28/7/2025. Three orders I will show. One is 28/7/2025.
That is in criminal division 3.
My lord, three.
Yes.
3, 4, both the orders were passed in both the case. Is a link matter. So if you see 28/7/2025, Lordship got it? 28/7.
Yes.
Just I read that order. Learned Counsel for Respondent ED has submitted he is indisposed today and seek adjournment to be listed on 11th of August 2025. Learned Senior Counsel for Petitioner has also stated he has filed an IA seeking permission of the court to file an additional affidavit. List the IA along with the main petition on 11th of August 2025. Learned Counsel so and so appears to an VC endeavors him to dispose of the matter. Interim order passed 30th shall continue till the next date. Now, after that, if your lordship looks into the order of 4/8/2025, 4/8,
The IA.
yes, 4/8 in the IA 16 of 2025, which is now being listed. 16 of 2. Lordship got it? Now see kindly 4/8 Learned Counsel appearing for petitioner. It is stated by order dated 28/7/2025 that this matter was direct to be listed. However, the matter has wrongly listed. Respondent ED Mr. So and so has also agreed accordingly list this matter on 11th of August 2025. So accordingly on 11 August 2025, an adjournment was sought on behalf of me for bereavement, and lordship was kind enough, and my learned friend Zoheb has also didn't object to it. That's the position of the case. The matter has been listed today, my lord. Now we file an IA. If a lordship looks into my IA, 16 of 2025, IA. Kindly see 16 of 2025.
Yes.
Now your lordship will look into this IA. And I will trouble your lordship in one order, which I have annexed on 21/7 at page 9. Page 9. May I just read this order with your lordship permission?
Yes.
Page 9, order is 21/7/2025 at page 9. Can I read this order? It is, I'll tell your lordship what is this about. In criminal revision 3 of 2025, this IA has been filed by them. It's a case, basically a complaint case which has been filed by ED. I'll just tell the background so it will be easier, quick to understand. So, my lord, an ED has filed a complaint case before the special court at Dimapur under 45 and 44 and 45 of the prevention of money laundering case before the special court. Now, it is like a charge sheet, you know, unlike a criminal case, it is a complaint which we normally say in an ED case.
Yes.
It has been filed. So, it is like, my lord, a complaint case where a summon has been issued. And, my lord, it is like a complaint and summon was issued against petitioner along with 299 accused. 299 accused. Now, in this way, my lord, summons were received. My lawyer appeared in the trial court. Now, time to time, the date was given and personal exemption was granted also, so far as my petitioner is concerned. Now, on a particular date, because I just want to tell the background of this case so that it is easier why this IA, why I'm seeking an IA to be filed. My lord, your lordship, when the matter was taken up by the court, by trial court, on 2/7/2025, my lord, an application was filed by ED, IA 230 of 2024, an application filed by the ED, and they are saying in the trial court, and they said that this is the case where the accused is avoiding, that is, a petitioner is avoiding interrogation also. He fled away in Dubai. So, open-ended non-bailable warrant should be issued. And this was an off date, IA 230 of 2024. This is on 2/7/2024. Now, on that day, without giving any notice to us, my lord, and this application was allowed so far as by the learned trial court is concerned. Now, then it proceeded, my lord. Now, on a particular date, 2/9, again, they file an application before the court. That is also an update that I should be declared as a fugitive economic offender because a non-bailable warrant of arrest is subsisting. Now, two orders are being put to challenge before this court, which is by way of criminal revision. That is 13/12/2024. This is in criminal revision 2025. Item number 3, and item number 4 is a criminal appeal, which has been filed by us. That
only one correction, Dr. Das.
Yes,
only one
yes,
correction.
yes.
We have not filed any IA here seeking declaration as fugitive.
No,
It is
correct.
You have been declared as a fugitive. You have challenged that. So for correction.
No. You have filed an IA. You have filed an IA before the trial court.
It's not an IA, sir. It's a petition under the Fugitive Economic Offenders Act.
No, I know, but there is an application which has been filed by them declaring me as a fugitive economic offender, my lord. This particular was heard, and ultimately I am been declared as a fugitive economic offender. Now, this too has been challenged before the court by the criminal revision 3 of 2025, and one is a criminal appeal. Criminal appeal 1 of 2025. So these two matters were listed before this court. Now, my lord, 3 of 2025. Now, there are various orders which have been passed by this court. Now, in this court, first order which was passed by this court was in link matter in both the case, saying that no coercive measure should be taken, and the matter will be taken up subsequently. Now, 3 of 2025 was taken by this court after filing the objection by the ED, and it was heard. And thereafter, an interim order was passed by this court, which, your lordship, there is an interim order saying that the order of 13/12/2024 is state. This is the position, because 13/12/2024 is a non-bailable warrant to be executed. And we said on the face of it, the court misinterpreted, because 5/9/2024 that was recalled by this court. So by the learned trial court. So whatever may be, these two matters are pending, and there is a stay in respect of both the matters. Now, time to time, the objection was filed. On the last occasion, my lord, an application has been filed by the ED in respect of 3 of 2025, that is 13 of 2025, and IA was filed. And your lordship will kindly see, we file objection. And the order that has been passed by this court is at page 9 of your lordship, is taking 16 of 2025. Right, my lord? Your lordship, am I
Now there
clear to your lordship?
If I may just interrupt you.
Yes.
There were two prayers made. The second prayer was rejected. And
Yes.
the first prayer praying for urgent hearing of the connected criminal.
Absolutely, your lordship, absolutely correct.
Giving them a liberty to file an additional an affidavit to bring on record subsequent events. Now,
my lord has read the order before your lordship has read the order. Your lordship was very quick in this matter.
Now, if I'm to understand correctly, since they have not filed any additional affidavit, you are seeking leave to file an additional affidavit and then have the matter heard.
Absolutely, your lordship is right, because lot of things has happened in between. Lot of things has been in between, my lord. That is why your lordship will kindly give us liberty to file an additional affidavit, so that my lord, the ED doesn't say anything about us, saying that no, look here, this is what has happened, this is what happened, he has gone to Dubai, there is a there is a lookout circular, so we want to bring it before this court. All this what has happened subsequently. In between, I'll tell your lordship, my lord, when this matter was pending before this court, and there is one judgment of the Supreme Court, Tarsem Lal, which has been quoted by this court at page 9, my lord, which was my argument before the learned court, that once the complaint is filed, now it is the prerogative of the court. Now it is under the hands of the court. You cannot arrest under section 19.
In any case, when that has been settled by the order that we
Yes, yes.
not going
So,
to that.
no,
Yes,
no.
you have any objection on the sir? You have any objection on the filing of an additional affidavit, counsel for ED?
I think my Joab is muted. Joab, you are mute. He is mute.
Yes.
I think Joab is. We could not hear you.
You are not
Joab,
audible.
you could not hear.
Still not audible.
No. My lord, they filed an application for production warrant when the matter was pending on 4/8/2025. After this order, my lord, only for the purpose of arresting us. And there is an order passed by a high court saying the non-bailable. That is the argument which was made, and this order was on 21/7/2025. And that too, my lord, an application was filed by the ED without giving a notice. An order has been passed. This is exactly opposite to the order that has been Supreme Court direction passed in Tarsem Lal. Can they do it, my lord? At least a notice would have been issued to us.
Yes,
So what?
Should we? You have any objection in us allowing this IA to file an additional affidavit within a certain period of time, and thereafter the matter be taken up for final disposal? Can you hear me?
I think, and what your lordship will be shocked, the ED has filed before the learned special court and saying that High Court has passed an order in a fragile ground. In a fragile ground. In a fragile ground. That is a statement that is made by ED.
And it was based on incomplete and misleading representation.
Incomplete and misleading representation. That was the application they have filed. And without hearing us, that was allowed.
Today, I think it will suffice if your application for filing an additional
Yes.
considered a matter is fixed for a final consideration at an early date.
My only request is, my lord, the IA that I had filed.
Yes.
My learned friend says this order may be taken on record as a subsequent event. The order is already available in the court file. So it is already the subsequent event is available from the court file.
Where is it available? Which file?
The order was passed, my lord,
in 13 of 2025, which they have filed IA.
That's right.
13 of 2025, which is a disposed of matter. Disposed of.
No. The IA is disposed of, not the petition. So the order sheet continues to remain part of the court file. Please see the IA, my lord.
Yes, we have the IA. Tell me the page number.
The order that my learned friend is referring to, my lord, may please see the order at the top. This is an IA criminal 13 of 2025, which has been filed in the criminal revision. Now this criminal revision is pending and listed today. So my submission is that even if my lord takes this order on record, there is no problem because it is a court order.
Is that the only document you would like to bring on record, Mr. Das?
There are few other orders which we bring into records. I'll tell your lordship why we are troubling this court.
My lord, my
I'll tell your lordship that some application.
I'll point out the problem.
There are 2, 3. 1 second. My lord is asking very relevant. Is this document you want to bring, or there are other documents?
So,
if
Mr.
this
Das, you
document,
have,
no, this my lord is asking me, that's why I'm giving a reply to it. This is not only the document, there are few other documents which has happened
What we will do,
after this order was passed, my lord, which is not on record brought by the ED.
what
My
we will,
lord,
what
yes,
we propose to do is, we will
yes,
give one opportunity to file an additional affidavit, bringing on record whatever you want to bring
right,
on record.
absolutely correct.
We will
Yes,
fix a date,
yes,
no further adjournments,
Correct.
take the matter for final consideration.
yes,
I'm deeply obliged. I'm deeply obliged, man. And but that is a yes, but there is an interim order in 3 of 2025. That
That
will
will
come.
extend till the next date.
Yes, I'm sorry. I'm deeply obliged, my lord. I'm deeply obliged.
If you can agree on a convenient date for both of you.
My lord, if my lord is not inconvenient, my learned friend Zoheb has no difficulty. Can it be fixed on 27?
my
27,
request is, 27th is fine, yes.
27 is fine for you?
Yes,
For
27th.
of this month.
Yes.
That is a Wednesday. It's a
Can it be the 28th, my lord? 28th, which is a Thursday.
28. My
27.
lord, my lord, why I'm saying that it spills over on 28 also, at least 27, 28, there will be 2 dates.
Very well, 27, 28, my lord, if it's convenient to the court.
27th is a leap day here. It's a
Oh, I'm sorry. Let it be on 28, my lord.
28.
28.
And my only request is, my lord, that whatever
Please.
pleadings they need to file, they can file it at least 3 days in advance prior to the next date, so that we get a chance to see it. If generally it comes on that very date.
Okay. Heard Mr. D. Das, learned senior advocate, assisted by, who is this? You are assisted by, sir? I'm not getting it.
Das. S. Das.
IDAS and SDAS. SDAS and IDAS. SDAS and IDAS.
IDAS. Learned counsel appearing for the petitioners. Also heard learned counsel appearing for the ED. This is an application filed by the petitioners seeking leave to submit an additional affidavit in the criminal revision to bring on record the subsequent events in the instant case. The learned counsel for the ED has submitted that there would be no objection to bringing on record subsequent events, provided the said affidavit is filed at an early date, so that the matter can be taken up for final consideration on the next date. Accordingly, this IA is allowed, requiring the petitioner to file the additional affidavit on or before 26th of August 2025 with advance copy to the learned counsel for the respondents. Full stop. On a joint prayer, the matter be listed on 28th of August, on which date the matter shall be taken up for final disposal. Interim orders passed earlier this one you write in the criminal revision petition, but here only you can see. Interim orders passed earlier in the.
My lord may say, if any, because in one of the connected cases, there is no interim order. Where they've sought quashing of the complaint, there is no interim order. So interim
No,
order,
that is item number 7, my lord. Item number 7. Please don't mix up that also.
in case it's a common order, I'm just.
No. It's not a common. It's 7 is separate.
We'll come back to 7.
Yes.
What did I write the last line? No, the line before that. For final disposal, interim orders, if any, in the parent petitions to continue. That will do, sir?
Yes, interim order continues, my lord.
Yes, I said so.
Is there interim order? And 4, there is already an interim order. Item number 4, there is already interim order until further orders, my lord.
We are passing the orders in both of them.
Yes, correct. My lord, yes, and the matter has been fixed on 28.
28th, and
Yes.
you file your additional affidavit by the 26th.
Yes. I like to point out.
With
I
advance
like to
notice.
I like to point out one thing, my lord. It disturbs the court, also disturbs me also, that how a trial court, we have great respect on trial courts. I just want to point out one thing. Great respect. I practice in a trial court, my lord. I know trial court, my lord. The orders are being passed, all ex parte and notice without issuing a notice.
That's
On
not
the
the
basis
I'm
of
sorry, that's
on
not the subject
production
matter.
warrant has to be executed, my
Mr.
lord.
Das, that's
And
not you file. If there's
fragile
any
order.
breach, no. If there's any breach by the trial court, you file a separate petition
No,
or an
we'll do it.
application.
We'll do it. We'll bring
Yes.
notice to the court.
Yes.
All the time ED are filing all an order applicant expertise.
I genuinely feel a fugitive who's done an offense of 2,200
I
crores.
would request both the councils to give a quietus now since the orders have been passed.
No, thank you. I'm deeply obliged.
Only one indulgence, my lord. Only one indulgence. Lord had observed orally if it can come in the order, no further adjournments by the petitioner. That's
no,
or
that
any party.
particular. We are not seeking adjournment.
I
It
have
is not
expressed
that
my order
intention.
that the matter will be taken up for final disposal.
Yeah, then
Very
what?
well. Very well.
I'm
Leave it at that.
Right. I don't want to embarrass my learned friend, but the order sheets will tell a different story.
No. It's not that. If this.
Now, I will have an objection because
My lord,
that we proceed
if now I'm telling straight, if my mother-in-law has passed,
No,
and if
I
there's
did
some
not object,
objection, I'm very
Mr.
sorry
Das.
to say.
On that, I have never objected.
I'm sorry to say.
On that, I've never objected, Mr. Das.
Yes.
The moment I heard, I
Don't say
expressed
all
my
this.
condolence.
Being a senior counsel practicing in this court, I don't take any adjournment.
No, this is embarrassing. I'm making a request. Allow me to proceed with the cause list.
Yes.
I'm obliged.
I'm sorry, my lord.
Okay.
If I'm sorry, I'm hurt your lordship. I'm sorry, my lord.
It's okay.
Item number
obliged.
7. Item number 7, my lord.
Number 7.
It is a complaint. There is no stay in this case, so let it be fixed together. If it is not inconvenient to your lordship, my learned friend, there is no interim order in that case, my lord.
Any objection getting it fixed on the same day?
My lord, only thing is the scope of challenge in item 7 is quite different. As far as 3 and 4 are concerned, one is a challenge to the issuance of NBW, which is a prerequisite for issuance of an FEO, that is a fugitive offender.
We will look into the substance of the petitions on a day they are taken up.
Yes, so my request is
please listen to us. Please listen to us first.
Yes.
We can't be kept interrupting like this. Please listen to us. My only question as of now is, do you have an objection if the matter is taken up on the same day as the other two?
My lord can take it up. My only submission was the scope is different. If it's segregated.
So you argue separately on that day. Do we need to be done it? Yes, on a joint prayer made by the learned counsel for the parties. List this matter on 28/8/2025.
I am deeply obliged, my lord.
Obliged, deeply obliged.
Item number 8 and 9.
Yes, Mr. Devnath.
May I please, my lord?
Yes.
Lordship, this is an application for condonation of delay, Lordship, of 482 days, Lordship.
The number of order sheets is more than the size of your petition.
Lordship.
Huh? Why so many dates? Yes, how many days delay?
Lordship, 482, Lordship, 482, Lordship.
What is the reason given?
Lordship, I have explained it at para 6. If I para 6, Lordship. May I read, Lordship?
Yes.
Where the applicant has a divisional office in Nagaland, it has a regional office in Gauhati, Assam. Appellant's Divisional Office, on receipt of the judgment dated 12/9/2022 from the MSCT Kohima on 15/11/2022, forwarded the same along with the file to its regional office in Gauhati, Assam on 17/11/2022 for approval advice in preferring the appeal. The appellant's regional office, on receipt of the entire file folder, forwarded the file to its panel advocate at Gauhati for obtaining the legal opinion. The appellant's counsel based at Gauhati furnished the legal opinion on 30/11/2022 to the regional office. The appellant's regional office, through office letter department legal dated 1/11/2022, forwarded the file to the appellant's divisional office to prefer the appeal before the Honorable Gauhati High Court Kohima bench. The appellant's divisional office, on receipt of the entire claim folder from the regional office, forwarded the file to the penal counsel at Dimapur White Letter Department legal dated 5/12/2022 for preparation and filing of the appeal against the impugned order dated 12/9/2022 as advised by the regional office. However, the applicant's counsel in the meantime was busy for his mother's treatment at New Delhi for 2 months with effect from 22/12/2022 till 22/2/2023. The applicant's penal counsel, after going through the entire claim folder, could find that few vital documents were missing in the file, which disability certificate, evidence on affidavit, and cross-examination of the claimant, police investigation report. As such, the counsel intimated the insurance company to arrange the documents by letter dated 31/3/2023. The insurance company thereafter contacted the trial counsel based at Kohima and requested her to arrange the same. The trial counsel, after receiving the uncertified copies of the said documents, forwarded it to the insurance company on 12/9/2023. The insurance company, after receiving the said documents, forwarded it to the applicant's panel counsel at Dimapur on 19/9/2023. The applicant's panel counsel, while preparing the MSc appeal, had fallen sick from mid-October 2023 and developed typhoid and was indisposed for nearly a month. However, unfortunately enough, counsel's paternal uncle expired on 29/11/2023. As such, the counsel was under bereavement from 29/11/2023 to 10/12/2023 and had to attend the last rituals performed in Gauhati. The counsel could prepare the appeal and connected interlocutory petitions and forwarded the same to the applicant's divisional office in Dimapur on 1/4/2024. The instant appeal was finally filed on 5/4/2024. The period of appeal being 90 days from the date of judgment dated 12/9/2022, it expired on 10/12/2022. Thus, there has been a delay of 482 days in filing the instant appeal, and the delay has been caused due to the reasons stated above and not due to willful negligence or default on part of the appellant company. As such, the said delay in filing the appeal may be confirmed.
Yes. The respondent number 1 and 2 have been 2 and 3 have been struck off.
Not
Or one of them struck off. Who was struck off? 3 has been struck off. 4 has been struck off. Yes, who's appearing for 1? Opposite party 1? Yes, you are objecting to the
number 1, Lordship.
You have any objections?
Yes, Lordship.
Did you file your objections?
Lordship, I have prepared one small gist. May I forward on copy?
I have that on record if I'm not wrong. This one?
No, Lordship. I have prepared this gist of my argument.
I think it is the same one.
That was filed earlier, but I have prepared a.
You've given a copy to Mr. Devnath?
No, Lordship.
It is my gist only.
Only a gist, okay.
Yes, Lordship, in page number 2, Lordship,
Yes.
the total delay is actually 575 days, Lordship, not 487 days.
Why so?
Here, Lordship. The judgment and award passed on 12/9/22. And appeal filed, till filing of the appeal, there has been a total delay of 575 days.
Why don't you file an objection bringing all this on record? At least he can answer this.
Okay, Lordship.
Mr. Devnath?
Lordship.
If he wants to file an objection, a very short objection, bringing on record whatever objection he has, the number of unexplained delay. But even then, even in your petition, I find one thing. You have totally spoken nothing from
Lordship, this is totally a vague petition.
December
The entire
to
delay is caused because of the lethargy and
December to December
Yeah, Lordship.
2023
Lordship.
to April 2024. You go totally blank. Why?
No, Lordship,
Page 7. Come to page
here,
7. The
Lordship,
last
at page number 7, Lordship.
7 last 4 lines starts with the word month. The last 4 lines. You have it?
Lordship. However, Lordship,
Uh-huh.
starts with the word however.
Yes.
Lordship,
No.
however, however, unfortunately enough, Council's paternal uncle expired on 29/11/2023.
Yes.
As such, the Council was under bereavement from 29/11/2023 to 10/12/2023, Lordship,
Yes.
and had to attend the last rituals performed at Gauhati. The Council prepared the appeal and connected interlocutory petition forwarded to the same to the applicant division office on 1/4/2024.
So you see those 4 months. What did the company do to pursue you? Should you be taking all the blame? 1 week.
Lordship.
Uh,
Lordship.
I shall file on it 1 week, within
1
1
week.
And matter will be heard on
The
8
week
September.
thereafter.
8
Would
September.
you require some time to reply, or will you argue?
Lordship, I have to seek the instruction of the company, Lordship. I'll intimate the company by today itself, Lordship.
See, this matter has been going on for almost the last 1 year.
Lordship.
Not.
Otherwise also this case is pertaining to the year 2015, Lordship. Very old case.
No, the order
That is
was
the
passed
MSC
in
case,
24. The order was passed in 24.
Lordship.
Incident may be of 15, but there was a delay, I don't know, in passing of the orders by the tribunal also.
Tribunal order passed on
24.
12/9/22, Lordship.
22.
Yes, Lordship.
22.
Yes, Lordship. And they were asleep over the entire period. Only after filing of the execution they wake up.
You bring on record your objections specifically.
Lordship.
We can pass a specific order either allowing or disallowing the
That is
condonation
after court.
petition.
Yes, Lordship.
But in the absence of any objection here, it will be upon me to calculate all the days and try to find out faults in the petition. I'm not supposed to do that. You point out the faults, we'll decide the matter.
Otherwise also, Lordship, in my gist of argument, I have calculated the entire things.
I
Case number 2,
understand.
Lordship. Yes, Lordship.
I understand, but you have not filed it, you have not given him a copy. How do I decide on that?
I shall file it, Lordship.
And tomorrow Mr. Devnath will be saying that, look, I did not have an opportunity. No, we don't want that. So you take down.
Lordship, as my senior colleague will be submitting his objection, if I may be given a copy in advance so that I can have the approval from the company whether to file reply or not, Lordship.
You are Mr.
B.N. Sharma.
Heard Mr. Vikramjit Devnath, counsel appearing for the applicants. Also heard Mr. B.N. Sharma, who is appearing for the sole respondent, who seeks a week's time to bring on record the objection of the opposite party to this petition filed for condonation of delay in preferring the MSc appeal. The prayer of Mr. Sharma is allowed. The objections, if any, be filed within 24, not on 24, by 27/8/2025 with advance copy to the counsel for the applicant. Stop. The matter will be listed again on the 4th of September.
8 September, Lordship.
8th of September 2025 for further consideration, and by which time the applicant may respond to the objections and may file their response to the objections filed by the opposite party number 1. It is also observed that the matter has been pending for a long time. An attempt will be made to dispose of the IA on the next date. Will that do, sir?
Deputy Operator.
10.
Item number 10. Yes.
Yes, my lordship.
Yes.
My lord, I'm mentioning on behalf of senior Gauhati for respondents, my lord.
Yes.
My lord, we are yet to receive any instructions from the ministry, so.
You are yet to obtain instruction.
Yes, my lord, from the ministry, so if.
Have you filed your wakalatnama?
Yes, my lord.
They have sent you an wakalatnama, they have not sent you the instructions.
Yes, my lord.
We will not take this lightly. If they are giving you wakalatnamas to appear in a contempt matter, why are they not issuing instructions to you as to what has been done in the matter? How difficult it is for them to do so? Where are the respondents located? New Delhi.
Yes, my lord.
Shall we make it easy for you? We'll ask them to come down here.
No, my lord, if sometime.
They can come down here, they can give you all the instructions they want.
My lord, we have already communicated through telephonically.
That is what I am telling you. If they are not responding to the orders of the court, if they are not responding to the counsels they are trying to engage, I think they can come and present the case themselves.
Then, my lord, if
Where is the difficulty?
If last time may be given to me.
Huh?
Last opportunity may be given to me.
Where is the order which has not been complied?
27/11/24, man. In WBC 30/23.
What was the orders passed?
Page 10 of the writ petition.
Huh?
Page 10 of the contempt petition.
No, where is the direction to the counsels, to the respondents? What is the direction?
The direction was to regularize the services of the petitioners. It's on page 21. Operative portion is para 29.
Any appeal filed? Any review filed?
Lord, I'm not fully conversant since I'm not a settlement consultant.
No, see, when orders are passed by this court, we can understand you having a difficulty in complying with it. But absence of instruction will not be taken in this court. If they have if they can send you a wakalatnama to appear in the matter to defend them, they can at least give you instructions as to why or what has been done. You are appearing for the respondent number?
All the respondents on behalf of.
All the respondents?
Yes, ma'am.
Then it is a bigger deal.
On behalf of Gauhati.
Who is respondent number 4? Kindly look at respondent number 4. How far is Medzifema? I saw it on the way here, not very far. Why is he not giving you any instructions? Medzifema is on the way from Gauhati to here, no? Quite near, not very far. 1.5 hours, 2 hours drive, I don't know. He can come at 3 o'clock. What is his difficulty in giving instructions?
If I bring my lord, since my senior is arguing this matter, so if this matter could be passed upon me.
Mr. Yangavati?
Yes, my lord.
When have you filed your wakalatnama? Okay, you filed it on 17/7. Sorry, it is on 5/8. You are Mr.
Jingyang Oman.
Appears for Mr. Yangarwati, who is stated to appear for all the respondents in the matter. The court is informed that though the wakalatnama has been filed, the respondents have not given any instructions regarding the compliance of the order of this court. Mr. So-and-so appearing for Mr. Yangavati, prays for A week's time. How much time? Week? 1 week, 2 weeks, how much?
My lord,
But
3
this
weeks.
time you have to have your instructions, you have to have your affidavit, yes.
Yes, my lord.
How much time?
If 3 weeks time, maybe
3 weeks. Praise for 3 weeks time to receive his instructions. With reluctance, this court is granting 3 weeks time for filing affidavit in opposition by the respondents. It is noticed that by the last order dated 21/7/2025, such opportunity was already granted pursuant to an earlier order, referring to an earlier order dated 11/6/2025. It is made clear that repeated adjournments are not appreciated in the court on the ground of absence of instructions. It is expected that the affidavit in opposition will be available on record by the next date fixed. List on, give me a date.
This matter will be fixed on 11th of September, man.
11th of September. Today is 18th, 25th, 1st and 8th. Okay, 11th of September.
Adjournment.
Ask them to give their instructions. We don't want you facing situations in the court, huh? Okay.
Item number 11.
Item number 11. Yes.
May I please, Your Lordship?
Yes.
My Lord, given the nature of the case, my submission will be very simple. My Lord, I am petitioner number 1, approaching this honorable court under section 528 BNSS, praying for quashing of the FIR and the subsequent criminal proceeding against me on the ground that settlement has been entered into between me and the complainant, who is none other than petitioner number 2, my Lord.
Both of you are before this court.
Pardon, my Lord?
You are both before this court, the complainant and the informant and the accused.
My Lord. So, my Lord, the complainant, she is the grandmother of the victim. The allegation against me is that I physically abused the victim who was under my guardianship. My Lord, it is not disputed that the victim was me for the past 6 years, that is, during the commission of the alleged offense. Also, the victim was 16 years of age at that time, my Lord. Now, I was taking care of the victim. I was also taking care of her education. However, due to a minor lapse in judgment, the said incident occurred, and therefore the criminal proceeding against me. Now, while the pending of the criminal proceeding, my Lord, settlement was entered into between me and the complainant, and witnessed by my husband, and also witnessed by the mother of the victim. The compromise deed, my Lord, is at page 25 to 27.
No, we go to the charge sheet first.
The charge sheet, my Lord,
page 20
starts at page 20.
Silver coated Nagada, wooden dao.
So, my Lord, I was charged under section 323, 324 IPC, with section 75 Juvenile Justice Act.
So was arrested under recorded residence. She has 2 daughters. His daughter is in LKG and his daughter is 1. She is doing schooling. Her relation towards the child was good and she was representing her by even after the part of her first injury. The child changed her behavior and was caught red-handed twice possessing tobacco when she inquired about Shilari. That time she slept on her face and put her hair for line and pulled her hair. Okay. She checked her daughter's water bottle to see whether it was liquid and she found it was too hot. On inquiry, the child she fetched the hot water from the flask and mixed cold water as it was too hot. And she refused and she mixed the unboiled water from the rice cooker. Backside shoulder with the wooden dowel. The next day, the child informed her uncle and cousin that the child's mother showed the photo of Yes, what about the victim? What does the victim say?
My
What
lord,
does the victim say?
I believe that is a question for the learned prosecution.
No, you are here with the informant and the accused.
My lord.
The informant is the grandmother of the
victim.
Grandmother of the victim.
My lord.
Yes. What do you say?
The victim is at para 2, Your Lordship, the statement of the victim.
Where?
2.
Page?
Page 22.
Page 22.
Yes. Charge sheet, Your Lordship, page 22, para 2.
The victim so and so. After the So where is the victim now?
Now the victim is, as per the charge sheet, it's there. She's with the parents now.
With the parents.
Yes, so she's gone back. The parents
Now,
have took her back.
where is the compromise deed?
Page 25 to 27, my lord.
Yes.
And XRC. Three pages, with the permission of the court, my lord.
Yes.
I may be allowed to bring your lordship's attention to just one point that will sum up the entire compromise deed.
Yes.
My lord will find it at page 27, point number 5, my lord. Page 27, point number 5. It is a very short paragraph. May I be allowed to read, my lord?
Yes, please read.
Point number 5. That the parties have mutually compromised among themselves in true Christian spirit, and as such, the first party has agreed to discontinue any criminal proceedings against the second party. So my lord is very well aware that this honorable court has the jurisdiction and the discretion to quash criminal proceedings based on settlement between parties.
What is this criminal petition? It is of somebody else.
Pardon, my lord?
Page 28. What is page 28?
Page 28. Page 28, my lord, is a reference to a judgment passed by this honorable court in a previous matter, where the nature of the case are identical.
What were the facts there? In that case, what was the fact?
I may be given a moment, my lord.
You have not gone through the facts of the case you are referring on. Okay, yes, PP, what do you say?
No, Your Lordship, here there is definitely a deed of compromise, Your Lordship,
Yes.
between the grandmother and where is the mother is the witness here. And as far as the charge sheet is concerned, Your Lordship, we have seen that the child has already gone back. Now we also see one situation here is that the accused is a mother of 2 minor child. But taking in that perspective, we also see that like there is a medical evidence also, Your Lordship. I don't know whether the elsewhere has come, but as per the charge sheet, the victim has also been examined by the doctor.
If the informant is coming to a compromise, if the mother of the victim is not pressing the matter forward,
Yes, Your Lordship, Your Lordship.
what are the chances of conviction?
No, Your Lordship, that's why, Your Lordship.
That is
there
one
a-
part, but the other part is
the gravity
when
of the case,
when
Your
the
Lordship.
minor has been assaulted,
That's why,
is
Your
it
Lordship.
a crime against a person or is it a crime against the state? You see, this judgment which you have given,
Yes.
that is why I was
It's
asking
very
you that
clear, Your
particular question. If you come to
Yes, my lord.
Page 31.
11,
Page 31, page 31.
Page 32.
Page 31. In the case where this washing was allowed, if you come to page 31, what you will find? Para 7. Please read para 7.
A perusal of the charge sheet submitted on such and such date indicates that at the time of the incident, when the respondent number 2 was on her way to the shop, the petitioner suddenly came from behind and grabbed her arm and started asking her questions. On being so disturbed, the respondent number 2 shouted and called for help as she found the action of the petitioner embarrassing. The petitioner and the respondent number 2 were unknown to each other prior to the incident. It was in such situation the investigating officer, along with some other materials collected during the course of investigation, had submitted the charge sheet. Thus, it is evident that the allegation against the petitioner is about making physical contact and advance to the respondent number 2, which were found unwelcome by her.
So that was an incident where someone tried to catch hold of the victim.
Sexual
The
harassment
victim
case.
did not find it welcome, so she filed it, and then the court said, okay, fine. But then you come to page 33. Can you read para 61, available in page 33?
The entire paragraph, my lord.
33, it's not very long.
Para 61, the position.
That emerges from the above discussion. Yes.
May I continue? my
Yes,
lord?
yes, please.
The position that emerges from the above discussion can be summarized as the power of the High Court in quashing a criminal proceeding or FIR or complaint in exercise of its inherent jurisdiction is distinct and different from the power given to a criminal court for compounding the offenses under Section 320 of the Code. Inherent power is of wide plenitude with no statutory limitation, but it has to be exercised in accord with the guideline engrafted in such power. That is, to secure the ends of justice or to prevent abuse of the process of any court. In what cases power to quash the criminal proceeding or complaint or FIR may be exercised where the offender and victim have settled their dispute would depend on the facts and circumstances of each case, and no category can be prescribed. However, before exercise of such power, the High Court must have due regard to the nature and gravity of the crime. Heinous and serious offenses of mental depravity or offenses like murder, rape, and dacoity, etc., cannot be fittingly quashed even though the victim or victim's family and the offender have settled the dispute. Such offenses are not private in nature and have serious impact on society. Similarly, any compromise between the victim and the offender in relation to the offenses under special statutes like Prevention of Corruption Act or the offenses committed by public servants while working in that capacity cannot provide for any basis for quashing criminal proceedings involving such cases. But the criminal cases, having overwhelmingly and predominantly civil flavor, stand on different footing for the purposes of quashing, particularly the offenses arising from commercial, financial, civil, partnership or such transactions, or the offenses arising out of matrimony relation to dowry, etc., or the family disputes, where the wrong is basically private or personal in nature, and the parties have resolved their entire dispute. In this category of cases, High Court may quash criminal proceedings. If, in its view, because of the compromise between the offender and the victim, the possibility of conviction is remote and bleak, and continuation of criminal cases would put the accused to great oppression and prejudice, and extreme injustice would be caused to him by not quashing the criminal case despite full and complete settlement and compromise with the victim.
Okay. Now you tell us, where should we allow this?
My lord,
child has been hit, assaulted, marks.
My lord, I'm not denying to it. However, as I've stated earlier, the child was 16 years of age at the time. It is also reflected in the charge sheet that the relationship between the victim and the offender was relatively good. There were not much issues. However, in the charge sheet it also states that from time to time the offender would correct the victim. However, this present criminal petition, the FIR in that regard, was filed due to one incident wherein the accused is alleged to have physically abused the victim. My lord, if you look at the charge sheet at page 20, the para number 3.
Yes.
Para number 3 Here, my lord, it says that the victim was medically examined in district hospital such and such by the medical officer. And as per the doctor's report, the victim bore simple injury marks. My lord, the reason I'm pointing this out is because the injury caused of the victim being simple in nature, and also the maximum punishment prescribed, my lord, for the offences, that is 3 to 3, 3 to 4, and 75 of the Juvenile Justice Act, the maximum punishment prescribed is imprisonment which may extend to 3 years. In other words, my lord, the offence is not serious in nature, and therefore, given that the parties have compromised and also relying on a series of landmark judgments given by the Honorable Supreme Court, my humble prayer is that the criminal proceeding may be quashed and set aside.
Your objections?
Yes, Your Lordship. Now, Your Lordship, maybe it is more simple injury marks, but it is also reflected there were multi scars all over the body, Your Lordship. So, Your Lordship, it is the gravity of the case. We have to see, while considering the question of the FIR, Your Lordship, we see the gravity of the case, Your Lordship. And now we are giving a child under her care, Your Lordship, and under her care and protection, Your Lordship. If this has happened, Your Lordship, and if we allow, and if quashing of fire is allowed, it will undermine the rule of law, Your Lordship.
What do you say about these sentences? I'll just read it to you.
Yes, Your Lordship.
But the criminal cases having overwhelmingly and predominantly civil flavor stand on a different footing for the purpose of quashing. Particularly the offences arising from commercial, financial, mercantile, civil, partnership, or such like transactions, or the offences out of matrimony relating to dowry, etc., and the family disputes, where the wrong is basically private or personal in nature. It is not the case that this lady harms any child who comes under her care.
No, it's not.
This child was under her care.
Yes.
She found a few faults with the child, one hit there, one pinch in the ears.
However, Your Lordship, it will have a social impact also. Your Lordship, if you see the preceding paragraph,
I
also,
think
while
her
considering-
arrest and her other torture that she has undergone should be enough to remind this society that the child should not be handled like that.
Yes, Your Lordship, that is my key point, Your Lordship.
But
So-
allowing this criminal proceeding to go on, perhaps not only put the accused under a lot of pressure because of her children,
Yeah, that.
but
that,
also the parents and the victim herself, because she'll have to face a proceeding by giving witness in the court, attending court procedures and all that.
So, Your Lordship, that's why
You can avoid the turmoil.
my first submission is that at the beginning of my submission only, I have stated that taking into consideration, Your Lordship, that the accused is a mother of 2 minor children, as well as the gravity and the social impact it will have, Your Lordship. I feel that like it can be tried on merit also, but Your Lordship, I will leave it to your jurisdiction, taking into consideration that the accused is a mother of the minor child.
That is what now her trying to reprimand, or she may have gone 2 steps more than she was required to.
Exactly.
But would it draw a criminal? Should we allow a criminal?
I'll
Okay.
leave it to your jurisdiction, to your wisdom, Your Lordship.
Save some time. We'll not dictate the order in the court.
Yeah,
We'll dictate it on some other day. Keep it CAB. Please take down the attendance, and we'll try to have it day after tomorrow if possible. We'll try to deliver the orders.
My lord.
This is the first time it has come up.
No, my lord.
I think it's coming up for the third, because obtaining of the LCR took time, so.
So now, any date fixed in the lower court?
That we are
Any
not
date?
able to obtain, Your Lordship, that's why LCR was called.
Day after
up.
tomorrow.
Yeah.
You keep it CAB. We'll deliver the judgment day after tomorrow. Yes, CAB kar dejiye.
Much obliged.
Yes.
Obliged, my lord.
Four orders. Item number 12.
12, yes. 22. Contempt.
Yes, Your Lordship.
Oh.
Now, what happened is that, Your Lordship, during the pendency of this COP, appeal went. There was
Okay.
a stay, and
Okay.
because of that, like this COP was kept pending, was
Okay.
kept in abeyance, so till the outcome of the appeal. The appeal was, however, dismissed, Your Lordship. Meantime, the case proceeded.
Where is that order of that dismissal of the appeal? Can we see
Your
it?
Lordship, it was submitted the last time.
Uh-huh.
The Supreme Court has already dismissed it, Lordship.
Supreme Court also dismissed?
Yes.
Oh, you are in the soup.
Yes.
You are in
What
the
has
soup.
happened is, Lordship, I humbly pray before this Honorable Court,
Yes.
the petitioner were getting 31,350 fixed pay.
Huh.
Fixed pay. They were recruited as per the law, but they were given a fixed pay. Subsequently, it came to the knowledge of the petitioners that they were appointed in the state post creation post, and not under the central scheme.
This
Now-
is regarding the teacher,
Salary.
some teacher's
Yes,
salary,
yes,
whether they are supposed to
exactly,
get
exactly,
fixed pay or scale. That is the
Yes.
one.
Right,
There were different batches, 2016
Yes,
batch, something.
Yes,
like
yes,
that.
exactly.
I read it in the newspaper. I don't know about
Yes,
this.
Lord. So what has happened is,
Okay.
now forthwith from 16/3/2022, the
Yes.
Learned Division Bench directed the state government to provide them the post-creation pay scale, post-creation pay band. Now, the state government went to appeal in the Supreme Court, and Lordship,
When was it dismissed? Can you tell me?
Yes, Lordship, it was on 2025.
May.
Huh?
20th May
This year.
20th May. Now, yes. What is the state
Your
doing now?
Lordship, now, Your
May,
Lordship,
June, July,
Yeah,
August.
Lord, you should kindly appreciate that now we are in the orders, Your Lordship. On the last order, Your Lordship, there was a direction to
We have
implead.
already done.
Yes, so whether on impleading, Your Lordship, I have an instruction to appear on the respondent number 4 and 5, Your Lordship. There was a new impleadment, Your Lordship. Respondent number 5 and 4 and 5 here on the last occasion. So today I got an instruction that to appear even for this 4 and 5, Your Lordship.
And
And,
further instructions
yes, and further
as to what
instruction
they are
is-
doing in the matter.
Yeah, and further instruction
Have
is
they
that
given
like,
you the instruction? What they are
Lordship,
doing?
I received an instruction that a review has also been filed before the Supreme Court, Your Lordship.
That does not matter here, Lordship.
And yeah, Your Lordship, so some time may be granted, Your Lordship, so that like
My humble,
no, there might be something which could not be clarified, or I mean like it cannot be stated, like, and that's why a review has been filed, Your Lordship.
Just
Review
my-
is yet to be filed.
Review
2
is
months.
filed, it's filed.
You have the review
Yes,
number?
yes, I have the record.
just my own
Yes.
humble submission, Lordship.
Yes.
Because of this, they were getting 31,350 monthly. Now, after this, they have now withheld even that 31,350 for 5 months now, as of now.
Where is that order of the High Court? You show me the order of the High Court then. What was the order passed in the by the learned single judge?
Yes, Lordship.
Show me
The
that order.
operative portion is page 81.
Page
81.
81.
81 in my contempt petition.
No, show me the operative portion.
Yes, 19, page 81. I will just read out, Lordship.
Have you brought on record your statement that now they have not been paid for the last
I was
5 months?
No.
Actually,
Have you brought it on record?
no,
Do one thing.
what?
You file an affidavit saying that after the disposal of the Supreme Court,
Lordship.
they have not paid even your basic salaries
Yes,
which they had
yes.
agreed to for the last 5 months.
Lordship, let the matter come up.
You bring that on record.
Lordship, I'll do that.
By that time, you see that at least the salary which they are entitled to.
Your Lordship, that's why, Your Lordship.
We will take this to be a malicious act on the part of the respondents if they are stopping the salaries.
No, Your Lordship, we are under a bona fide belief that everything, Your Lordship, we are also making
See,
an effort, Your Lordship.
they were paid at a fixed rate.
Yes, Your Lordship.
Court said you pay them on a scale.
Yes, Your Lordship.
You went up in appeal. You went up to the Supreme Court.
Right.
Will they be denied their fixed pay?
No, Your Lordship, that should not be. However,
See,
Your Lordship, there might
once
be-
you pay the fixed pay, suppose you even comply with the orders of the court by giving them a scale. Their scale will be fixed at the fixed pay, whatever was at the fixed pay, 31,000, their pay will be fixed at 31,000. So you are not giving them any extra money on that. What you will give them is any increment or anything from a certain period of time from when the court directed you to do
So,
so.
Your Lordship,
But if you are stopping their salaries,
exactly.
then I think there are two, you come up with those judgments also,
Lordship-
madam. There are judgments of the Honorable Supreme Court saying that stopping of salaries is in itself contemptuous when the parties are in litigation.
Your Lordship,
Fresh contempt will come up against your officers, I'm telling you.
Your Lordship, I appreciate Your Lordship. Kindly give me time so that at least
All others
as to
review,
why, as to
review
why,
everything that we are trying to accommodate you.
Your Lordship, that's why, Your Lordship,
But
if I
if it
can
is an
really
act-
take an instruction as to why their salary is also not being paid, because there should be an explanation, because it's an undertaking as rightly observed by this
Lordship,
honorable
in
court.
my IA, my
There
lord,
should
can
be an
I read
explanation.
Which one?
What can there
Which
be?
no, you will not interact in between yourself. I had to stop someone in the morning, I'm not stopping you. Okay, you tell me your IA. Where is your IA?
Yeah, IA,
Show me that
97.
IA. But that IA is disposed.
Yes, it's disposed already, Your Lordship.
How can we take it on record
Yes.
again to consider something?
Dispose.
Then we can't take it to whatever was there on record now.
One
Is
is
it
for
not?
impleachment, one is for striking of, Your Lordship.
No, you file a proper affidavit on
Lordship,
record.
that they have not
And
been
you
paid, Lordship.
and
Let the
bring
matter
it to
come
the
up
notice
on-
of the court. In the meantime, you will have
Yes, I
10
will
days
also
time.
obtain instruction, so Your
10
Lordship,
days
some
time,
time may
yes.
be granted, Your Lordship.
Yes, please take the attendance.
Let the matter come up on Thursday.
You are Miss
Lordship.
Zimomi?
Yes, Lordship.
Yes, heard Miss Zimomi. General Counsel appearing for the petitioners. And your good name,
Livika, Your
Livika,
Lordship.
yes. Also heard Miss Livika, who submits that she has instructions to appear for
For newly impleted,
the
4 and 5 also.
newly impleted respondent number 4 and
5,
5.
Your Lordship.
4 and 5. You filed your wakalat number?
No, Your Lordship, here we
And
had some
would-
sitting order where we can appear, Your Lordship, without Vikalat Nama. We have an order of the government, Your Lordship, that the government advocate can appear for on the contempt petition.
Contempt is personal.
Yeah, it's personal. However, there is a guide, one
No,
notification.
even in Assam, we had that provision where government advocates were required to be engaged to the extent possible. Because we know the functioning of the.
That's true.
They are supposed to know how the government is functioning.
If that is the case,
But
Your
then
Lord, I
you
can
must
file-
have a wakalatnama or
Your
at least a
Lordship.
memorandum of appearance.
Your Lordship, I can file Vakalat Nama.
Miss Livika. Who prays for some time to file her memorandum of appearance in the matter. Ms. Zimomi has submitted that the petitioners have not been paid their dues for the last 5 months. Oh, no. Please see your recast petition. Synopsis. Second page. No, this recast petition is what? This one? Filed on 18th of November 2022. The recast petition you have?
Your Lordship, I have also got the copy of the request.
18/11/2022. It was filed on 18 November 2022. Take up your contempt petition, the recast one.
Contempt was filed prior to Supreme Court.
Yes, but even then I'm showing you. Hey, your people are. Okay, let me see the contempt petition. If it is there also.
Impleachment is just recent, Lordship.
I understand. No. Petitioners are creating a mess for themselves. Para 9 of your petition, you come to para 9. You have refused. I cannot take notice of that. Sorry. to find her. You've seen para 9 of your petition, contempt petition. Your petitioners have refused to take their salary. You made a statement on oath.
Lordship, this
See,
was.
page 33. Look at page 33. On getting the information, petitioners immediately submitted representation in protest, refusing to accept the salary amount.
That's why, Your Lordship, there should be an explanation, that's why.
Then,
Which one? Lordship in contempt.
yes, para 9,
Para 9.
page 33. They are saying either give us the scale or we are not taking the salary. You can't do that. See what have you written. On getting the information, the petitioners immediately submitted representation letter so-and-so in protest, refusing to accept the salary. And to direct DEOs not to credit the salary to petitioner's bank account stating internally as so-and-so. Is it not? You asked for that.
Lordship, this was in 2022.
Yes. Have you withdrawn that? Saying that, okay, now pay us our salary, we are hungry.
In my this implement, I have also incorporated some certain lines.
Wait. Show me. In the implement, it will not do.
And even thereafter, we have been getting salary till 2025.
Okay.
We have
20?
been getting.
You have been getting
2025. So starting from March till date.
Yes. Okay, you take down. What did I say? Yes, madam, the last line what we were saying. She pays for some time to file her memorandum of appearance. Yes, next. Ms. Zimumi has made a statement in the court that the petitioners have not been paid their salary from April 2025. The learned counsel appearing for the respondents shall also have her instructions on why the salary of the petitioners have not been paid from March 2025, and if not paid, and there is no legal impediment, by what date would the arrears, at least from March 2025, would be cleared. She would also be ready with instructions as to what further steps have been taken by the respondents after dismissal of the SLP by the Honorable Supreme Court. Next, you write down a copy of the order dated. It's already on record, I think. Oh, it's already on record. Strike out the last line. List again on when do you want it?
Just Lordship, a short time.
Yes,
Your
ma'am.
Lordship, at least 2 weeks.
2 weeks.
A fixed day maybe.
25 first, we'll put it up on the 4th of September.
4th of September.
It's a Thursday. You will have nearly 3 weeks. Huh? 4th of September? No, 2 weeks. 2 weeks will be over on the 1st.
Your Lordship, let it come on 4th.
On
2 weeks will be over on the 1st.
Yes.
1 or 2 extra days.
Lordship.
4th.
Your Lordship, that will be by way of affidavit, or the instruction that I received.
It is always better if you file an affidavit.
Yes. I also.
Instructions are things which keep on changing. On an affidavit, you are on a better footing. Because he swears it, you don't make a statement.
Obliged, Lordship.
Yes. Next.
Item number 13.
13, yes. 13, someone was praying for time. But I had fixed it if I'm not wrong.
May I please?
It was not by me. Okay. Yes, have you filed your affidavit?
Lordship, in fact, I am not representing the respondent number 3 and 10. Yeah, I'm for respondent number 1, Your Lordship.
1.
Yes, I was making a mention on behalf of respondent 3 and 10 also, Your Lordship.
And that is what I'm saying?
Yes, Your Lordship. What I have been informed, Your Lordship, is that the case of the petitioner are already before the Treasury for pre-audit, Your Lordship.
It has been deposited to the
Treasury for pre-audit.
Pre-audit?
Yes,
Okay.
Yes. This is relating to time-bound scale of payment.
Yes, you take down Mr. N. Angami.
Lordship.
Learned counsel appears for the who appears for the respondent number 1 has today submitted that The learned counsel for the respondent number 3 and 10 is indisposed, but he has been instructed to inform this court that the, what did you say?
The case of the petitioner is before the Treasury.
The case of the petitioner is now before the Treasury for
Pre-audit.
pre-audit, which is one of the steps for complying with the orders passed by this court in WPC number 268 of 2022. It is noticed that the respondent numbers 3 and 10 were directed to file their affidavit by today. Full stop. At the request of Mr. Angami made on behalf of the counsel for the respondent number 3 and 10, list the matter after how many? 2 weeks?
2 weeks, madam.
2 weeks will do. 2 weeks, by which time the respondents number 3 and 10 will ensure that their affidavit is filed and on record. Full stop. List the matter again on the 4th of September for further consideration.
I'm deeply obliged, madam.
Yes.
Item number 14.
14. Yes, this is for what? Yes.
Complying to the last order number 2, dated 23/6/2025, was issued notice on 24/6/2025 to the respondent 1 to 7. I'm even to the former respondent.
Notice to respondent number 1 to 8, return unserved with the remarks not known, return to sender. Did they appear in the but they are all the claimants. Huh? They are all claimants. You have given the addresses?
Yes, Your Lordship.
How can they all be not known? Did you write? Heard, miss?
Medopisi.
Sorry?
Medopisi.
Okay. You will have to speak louder because I am unfamiliar with the names and I want to hear it clearly before I understand it. Okay. Heard, miss so and so appearing for the applicant. Perused service report, a perused office note dated 15/7/2025, which reflects that the notices issued on respondent number 1 to 8 have been returned unserved with the remark not known, returned to sender. Stop. Miss so-and-so prays for an opportunity to determine any known fresh addresses of the respondents where they may be served and to take appropriate steps thereafter. Full stop. Accordingly, list the matter on 2nd of September, on which day the applicant shall inform the court as to whether there are any other known addresses of the opposite parties. See, you take a chance Tell your company, they can try and find out what has happened to those people if they've shifted their address or something. Otherwise, it will remain unserved all the time. Then we'll have to strike them out later on. Yes. Because they will be coming to take that money. Some award has been given to them. They must have come to the lower court, given some identification. Find out. Give us the fresh address or something. You understand what I'm saying?
Yes, Your Lordship.
They must have taken the money from the lower court.
I'm sure.
They must have given some identification. Find out the proper address from there.
Okay, Your Lordship.
We'll try to help.
Much obliged.
For hearing. Item number 15.
Yes. Oh, that one matter. That matter.
Yes, ma'am.
What to do, sir? What to do? Deliver a judgment here. Huh? Anything you want to say on these two judgments?
Yes, please,
Yeah,
my lord.
against you.
My lord, in WPC 136 of 2024, my lord.
Yes.
Here the facts are different, my lord. Though the petitioner has seek appointment on land ownership, my lord.
Yes.
My lord, here the state respondent has invoked Rule 11 and 12 of the executive rules. Yes, my lord. Business executive, my lord.
Where is it? As per the Rule 11 of the Nagaland Executive, all the government shall be expressed to be made or executed in the name of the Governor of Nagaland. I mean, this is not a government advocate is saying that.
Yes, my lord. The government advocate has invoked Rule 11 and 12 of the business executive, my lord. And also in WBC 124 of 136 of 2024, advertisement has been issued.
Which was challenged.
Which was challenged.
Okay. And
Yes.
what about the other one?
And whereas that is not in the case of my case, my lord. And also here in the petition 136 of 2024, which the standard respondent is relying upon, is that here the agreement has not been signed by the authority, competent authority. Yes, my lord. So this case and
your
my
argument is that the facts being different, this case will not be applicable to
yes, my
your
lord. It's
case.
not applicable
Okay,
to
then.
my case. And my
What
lord,
about
it can and also with the second citation which my learned friend rely upon is on WA number 18 of K of 13, my lord.
Yes.
My lord, with regard this matter, the matter is still pending before this honorable court, my lord.
Is it?
Yes, my lord.
How come? Review.
My lord, recently one of the parties filed WA number 17 of 2025, my lord.
No, which party?
One of the party here, my lord.
Huh?
One of the party in the WA.
Already
18 of
it have been
13.
disposed of and
Yes, read appeal has been disposed of, but there several issues has been grouped up in this very case, my lord. So this has not been settled.
What is the other writ appeal number you are saying?
WA 17 of 2025, my lord.
Okay.
Yes, my lord.
Okay.
And also, my lord, here my case is that.
You want to rely on any judgment?
No, my lord. I'm entirely relying on OM of notification, my lord, 17/8 of 2018, my lord, where I would like to take your lordship to the same notification, my lord.
Yes.
That Annexure C, page 16, my lord.
Annexure C, page 16.
Yes, my lord. Clause,
Yes, we have it.
Clause A and B, my lord. Here it is written clearly that either it should be written or oral, my lord. And I'm relying on this, my lord.
No. Your agreement is a written agreement.
Yes, my lord.
And
Yes, my lord, written agreement, but condition is not that there that the service should be offered to the
the
petitioner.
condition is not there.
However, when agreement is executed, the government don't entertain, inserting certain conditions, not only in my case, but
you have
there are
this,
so many cases where condition is not being inserted in this kind of case, man.
okay.
And also, my lord, here, the respondent has admitted that the land has been provided by my grandfather, and there my late father was the witness, one of the witness. Yes.
But why did they not ask for jobs? Why did they wait for you to grow up?
My lord, during the lifetime
The land
of
was
my-
never yours. See, the land was your grandfather's.
Yes.
He donated a land.
Yes, my lord.
And whatever benefit had to come to him. He
No,
did
my
not
lord.
take any benefit. Then
My lord, any of the family member.
yes, but then he should have.
My lord, during my father's lifetime, he has submitted the representation before the state respondent. May I take your lordship
Where is
to
that?
annex here
Yes,
Page-
something was
page
submitted
21.
by your father. Yes, that my son may be given all.
Yes, my lord. Married, my lord.
Yes, page
21, my lord.
21. Okay, we'll.
Annex here H, my lord.
Now,
Do the superintendent of police, Kifli Nagaland, subject prayer for appointment?
just a
of-
minute, just a minute.
Yes.
Just a minute. There is a flooding here because of all the rain. इसमें भी लग गया? कुछ तो- How did this happen? Oh, I must have pushed this thing. No? Trying to adjust it. Do it. Yes, page 21 you were reading, sir?
Yes, my lord. To the superintendent of police, Kifli Nagaland, subject prayer for appointment of NEC sweeper against landowner of police station Seojungdong. Sir, with reference to the above cited subject, I have the honor to lay the following for favor of your kind consideration, please. That, sir, it is to bring forth into your esteemed knowledge that a plot of land where the police station Seojungdong has been constructed in our land, which the landowner is yet to be compensated in any form. This matter is clear in the knowledge of the department. Hence, as per order number PSQ, order number so and so, dated Kohima 19 September 2006, requesting the superintendent of police Kifli and issued to my son Sri Nole A. Sangdam, but to our other dismissal date.
Where is that order dated 19 September 2006?
My lord, that is not with me.
Then how did you write the letters referring to a particular order? You have referred to a particular
Yes,
order?
I got
You
it
have
from
that
the
with you?
office, yes.
You have that with you? Even if not filed, do you have a copy of it with you?
No, my lord. That could not be traced out. It was found in the office only.
Okay.
Yes, but to our other dismay till that it is yet to be materialized. Xerox copy of PHQ and to whom it may concern certified duly signed by ADC, Seojungdong, Head GP Seojungdong, Head GP Youngsdong Village, and Head GP Seojungdong, and a plot agreement. Therefore, your competent and justifying authority is requested to issue the appointment order as deserved, please. So this is the application submitted before the state respondent by my late father. And my lord, may I take your lordship to the affidavit filed by the state respondent, my lord?
Yes. Show us what you can. Where is it?
May I read from paragraph 4, my lord?
Where is that affidavit? This is the affidavit in reply, and this is the affidavit. Yes, show us.
That paragraph 4, my lord, that with regard to the statement made in paragraph 4 and 19 of the writ petition, the answering deponent humbly begged to state that as per the agreement dated 29/5/2003 executed between the petitioner father and the police department, and the land was donated free of cost to the police department, there is no mention of employment to be provided to the landowner in lieu of the land provided. It is also pertinent to mention herein that it is also clearly seen from the letter dated 7th November 2023 that the land was donated free of cost. Further, there is no record of oral evidence in the police department to provide employment to the petitioner grandfather. My lord, this submission made by the state respondent, and here they have stated that there should be an oral evidence of to provide employment opportunity. However, my lord, how can there be an evidence when it was made orally, my lord? Yes,
that is
my
why,
lord.
that is
orally
why,
cannot be.
That is why you again come back to that OM. The OM that you are depending upon, come back to it. What does it say? It says, very specific, you have page 16.
Yes, ma'am.
In other cases prior to so
Married, my lord.
Yes, yes, please.
Clause 3, A and B. First, I'll read A, my lord. In other cases prior to 26/07/2005 and subsequent to setting up to administrative and block headquarters on freely donated land, where a specific written or oral agreement exists providing for employment or other facilities to the landowners, the claim of the landowner for employment or other facility that department concerned shall refer the matter to the Deputy Commissioner of the district concerned, who shall examine such claim carefully, including whether any employment or other facilities, including contract or supply works, has been given in the past.
Now we will again do it. The department concerned shall refer the matter to the Deputy Commissioner of the district concerned, who shall examine such claim carefully, including so and so. Thereafter, the next sentence, written statement from the witnesses of the department concerned, district administration,
written statement
and yes, please go ahead, read.
From which what, my lord?
Written statement from the.
Yes, my lord. Written statement from the witnesses, that is, government officials of the department concerned, district administration, and village functionaries present at the time of such written or oral agreement should be taken by the Deputy Commissioner. The recommendation of
the moment you say there is a oral agreement, then he will take the written statement of those officials who were present at the time of the agreement, or he will say that there are no officials present, but there has to be an inquiry at best.
However, my lord, in my case, there was an official, my lord.
Huh?
Official was there from the concerned department.
Yes.
Yes.
So, if you had alleged any oral agreement, they would have gone for an inquiry. You did not allege the oral agreement.
Yes, my lord.
Written agreement does not contain the clause. So
when the agreement was executed, I was still a minor. I was
so we will have to go by what your major grandfather did at that point of time. He was a major. He could donate land. He did not want any job for his family.
No, my lord. The practice in the state of Nagaland is that when a land is offered, it's the honors lies with the state government, that any benefit is given to the government, to the landowners in any form, either in the form of employment opportunity, contract works, or monetary benefits are given to the landowners, my lord.
I understand what you're trying to say. I understand what you are trying to post, but the thing is, in the absence of the assertion in the repetition.
My lord, yes, explicit pleading has not been made. However,
even the practice, even to prove that that practice was prevalent, anything here, nothing. How do you prove that that was the practice, that we will only give land? The earlier OM of 2006 also you have not given.
My lord,
the letter of that SP or whosoever of 2006 or what, that letter I was asking you, that also you have not given.
my lord, The court can assess whether the lack of the plea.
Too burdensome.
Yes, my lord.
Too burdensome on us.
Yes,
Okay.
specific, my lord, specific plea is, minor oversight or a fundamental flaw that prevents this honorable court from addressing the issues, my lord.
Okay, we'll keep
My
that
lord.
in mind.
And my lord, on the last day of hearing, my lord.
Yes.
There was one witness where he was present, and he has executed this declaration that he was present in the meeting and orally they have
He
discussed.
has executed it now.
Yes, my lord.
No can do.
As my lord, I was minor and
That will not do. That will be stretching it too far.
yes, my lord. And also I'll take your lordship to the para 6 where the state respondent has admitted that I've donated the land, my lord.
You plead on what is available on record. We'll try to assess only that much.
Yes, para 6, my lord.
Yes.
Of the,
No one has been appointed.
yes, that with regard to the statement made in para 10 and 14 of the writ petition, the answering deponent begged to state that as per the available records, none of the family members of the petitioner has been appointed against any grade 4 post, nor any contract works were allotted to the petitioner family on the land ownership basis, my lord. They have admitted, my lord.
I will consider it. I'll keep that in mind.
Yes, my lord.
So we'll say, you show this is disposed of, take their attendance, and you'll have the order tomorrow, by today evening or tomorrow morning. We won't dictate it in court, it will be giving the whole court meetings.
Yes, my lord. My last submission is that, yes, I've not made a plea that there was an oral agreement, but your lordship may kindly consider that there's a discussion, or your lordship has to look into the matter whether the lack of the plea is a minor oversight, or whether that will, or a fundamental flaws will prevent this court from addressing the issues, my lord, in the interest of justice, my lord.
Okay, then. We'll do that. We'll check. Yes. This will be disposed of, and I'll pass the order in the chamber or there. You can upload it by evening only.
Okay.
Yes. Thank you.
Item number 16.
This is again a civil division. Yes. For mediation.
May I please, Your Lordship?
What is this? Oh. Resolved and settled between
Yes,
the
Lord.
parties.
Lordship, it has been settled, Lordship.
So, what is the procedure you follow here?
Lordship, if this matter can be closed basing on the settlement agreement, Lordship.
This matter has. By order dated 37/2025, the parties were required to appear before the registrar of the Gauhati High Court Kohima bench on 7/8/2025, whereafter the registrar was required to appoint a mediator for the parties. Today, the final report dated 11/8/2025 submitted by Mr. Sanjeev Rana, advocate and mediator, Nagaland State Legal Services Authority, is placed before this court, stating that the instant matter has been resolved and settled with the consent and in the presence of the concerned parties. Full stop. Okay. Ms. So-and-so appearing for the learned counsel for the appellant, appearing for the petitioners, and you are appearing for all?
for the respondent.
Okay. Mr. Sensei appearing for all the respondents.
Respondent number 1.
For the respondent number 1, state that the compromise, that the mediation has been settled in accordance with the report dated 11 August 2025. What about the other respondents?
Lordship, the respondent number 2 is the state respondent. Lordship, however, since the
Not
matter
required.
is yes, Lordship.
Not required. In view of the settlement arrived at by the parties in the mediation undertaken through the orders of this court, this petition is closed on settlement. No costs.
Much obliged, Lordship.
Item number
22. Yes. This is the last item for today. Yes, appellant.
May I bless your Lordship?
Yes, ma'am.
I am for the insurance. I am the appellant. So I have a small ground. So if my learned friend is ready.
All respondents served?
Yes, your Lordship.
How many respondents were there?
Respondent 3.
Learned counsel for, okay. 3. Who's appearing for 3? Who is 3?
No one is appearing for 3. But your Lordship, it's the vehicle owner, but
He
I
will
don't
not be
think,
interested,
yeah,
okay.
it's not a necessary party for this.
Okay. Yes, what is your ground?
My Lord, this is in a bill under Section 173 of Motor Vehicle Act.
Yes.
So I'm aggrieved by the impugned judgment and order dated 12/7/2023, passed by the learned MSCT Twain Sang and MSC 26 of 2019. We are the learned MSCT has granted 20,51,000 with 7.5 entries per annum. So from the date of filing. So I've
The date of
annexed.
filing, okay.
Yes. So I've annexed as annexure A, page 9. In my
Yes.
appeal memo, that is the judgment and order.
Yes. What is wrong in
So,
this? You tell us
yes, my only ground is that the learned member had passed the judgment and order without relying on the documents issued by the medical superintendent of Tuinsang. Herein it is stated that disability is 65% and the assessment is for the period of 1 year. That is till 2023 only. The certificate is only for a specific period. Annexure B, page 28, is the disability certificate.
Page 28.
Yes. If my Lordship may kindly turn to page 28, annexure B.
Yes.
Yeah, so in the below, number 2, reassessment of disability is.
What was the disability? Fracture of right orbital roof.
Yes.
And both legs displaced. Hey, what is this? Fracture, it's compound fracture. Both bilateral displaced nasal bone. Okay, nasal bone.
Yes.
Okay.
On the
The
face
condition
and the nose.
is non-progressive. Reassessment of disability is recommended after 1 year. And therefore, the certificate will be valid till 2023.
2023 only. So the reassessment certificate was not done. It's only for 1 year. But without reassessment, the Honorable Tribunal has passed the order assessing that the disability is permanent.
When did the Honorable Tribunal
The
pass the
order
order?
was passed on
Learned Tribunal passed the order on when?
30/9/2019.
Huh?
30,
No.
I'm sorry. 12/7/2023.
And when is the certificate?
Certificate.
2/7/2022.
Yes, Your Lordship.
So the time it was exhibited. Now, did the court say that it was a permanent nature?
Yes.
When did
So
it
that's
say?
the only ground.
So medical examiner certificate is not calling the author of the document, otherwise is not. So where does he say
Page
that
24.
for the disablement, how much is he giving? What is the amount given?
The relevant portion is page 24, Your Lordship,
20?
of the judgment and order.
Yes, yes. Page 24.
Yes, page 24.
Page 24, you.
Accident at the age of 21 years and become permanently disabled of 65%.
Where? Huh.
On the top.
Okay.
Page 24, yes. And become permanently disabled of 65%. So, basing on the certificate, temporary certificate only, but the court has come to the conclusion that.
So according to you, what should it be?
Actually, they should go for review. It's only for one.
But then every year, if it is so, every year you have to reassess his.
Your Lordship, I would like to place a judgment.
Please. So this 65% permanently disabled. You want to say it is not a permanent disablement?
Yes,
it is a
as
temporary disablement.
Yes.
Okay.
The
Yes,
Supreme
which
Court
page?
in Rajkumar versus Ajay Kumar,
Which page do you want me to see?
page number 3,
Yes.
para 9. Last
Para
part.
9. Oh, therefore
Last
the
part.
tribunal is supposed to be-
Therefore, the tribunal has to first decide whether there is any permanent disability and if so, to what extent of such permanent disability. This means that the tribunal should consider and decide with reference to the evidence whether the disablement is permanent or temporary. If the disablement is permanent, whether it is permanent total disablement or permanent partial disablement. But here in this case, the certificate states that it's only for 1 year, so it means it's temporary in nature.
Even then, with a broken nose, how can that be a disability? Because this disability has to be a disability to earn income.
Yes, Your
A
Lordship.
broken nose, how can it be a disability to earn income for all time to come? No. Okay. Anything else? Nothing else. Yes, sir.
May it please Your Lordship?
Yes.
Lordship, the certificate marked and exhibited in the court below is on consent.
Is?
Is on consent. There is
Okay.
no objection,
Done.
no cross-examination at all in
Yes.
this regard.
Yes.
So this is a new plea now. How they can raise the objection for the first time before Your Lordship, when it has not been raised objection at all in the court?
No, they
trial
have not.
court?
They have not objected to this certificate, which says
Yes,
that
Lordship.
there is a disability of 65%, which is temporary in nature.
No, Lordship.
While coming to the judgment, the tribunal holds that no, it's a permanent in nature.
Lordship,
That they will list it
exhibit,
now.
exhibit P9, Lordship.
Exhibit P9.
9, Lordship.
What was your evidence
PW1.
with regard to that particular certificate? What did
Yes,
you say?
exhibit P9, Lordship.
Exhibit P9, where is it?
Yes, Lordship.
Let us see.
In the certificate.
They don't.
Lordship.
Yes, Exhibit
Yes.
P9. Yes.
In the certificate, Lordship, in the serial number 1, after assessment, 65%, there is a serial number 1, 2, and
Yes.
3. In serial number 1, it is categorically stated that the injury is non-progressive.
Yes.
It is a non-progressive injury, means there will be no progressive at all. It is a permanent disability. And as such, because of that,
Yes.
the medical board advised to come again for reassessment. It may be increased also, Lordship. When a person having a 65% permanent disability, there is every possibility to increase it only, Lordship. Even Lordship, in page number 10 and 11 of the impugned judgment, Lordship.
You, what I was asking you before that is,
Yes.
you must have given your evidence.
Yes, Lordship.
Your name is Sanjeev Saikia.
Sanjeev Saikia, Lordship.
You have given your evidence.
Yes, Lordship.
Now, in your evidence, can you kindly show me
Yes, Lordship.
as to where you have stated that you have suffered a permanent injury,
Lordship.
a permanent disability?
My deposition in affidavit.
No.
first
You
of
have
all,
to. You have to do. Yes. Your affidavit
deposition
filed
in
on
affidavit.
17/11/2022.
Lordship.
Did you? Is it the one we are referring to? 17/11/2022. That is the affidavit you are referring to.
Yeah, Lordship.
Yes.
After Exhibit P9, Lordship, in page number 4 of my deposition in affidavit.
Where have you written that?
In page
Exhibit
number
P9 is the original copy of the medical disablement certificate issued by the board.
board, Lordship.
Yes, done.
That is also done under order of the court, Lordship. Court has requested the medical board by constituting the reassess the nature of the injury of the claimant. Accordingly, the medical board has reassessed that injury is permanent in nature of 65%.
Where is the permanent word written? Where is the permanent word written? You have to show me that word.
Exhibit P9, Lordship.
Yes, I am reading that.
Yeah, here
Yes,
it is non-progressive. The injury is non-progressive.
No, what? I'm just trying to understand. I'm not contradicting you. I'm trying to understand that language. It says it is progressive, non-progressive,
Yes, Lordship.
likely to improve.
Yes, Lordship.
So, likely to improve is another part.
Yes.
When we talk of a injury or a disability being progressive or non-progressive, as far as I have understood, if it is progressive, it will become worse and worse. If it is non-progressive, it will not become worse. It will stand where it is. When a disability progresses, it either progresses or it improves. Therefore, the last one, likely to improve. Either it will become good, you
Lordship,
come out of the improve.
My view is, Lordship, likely to improve means there is a possibility for recovery.
Yes.
And non-progressive means
It
there
will
is
not
no
become bad.
chances for recovery.
No.
Lordship, in serial number 3, Lordship.
Yes.
Serial number 3, it is written, serial number 2, Lordship, disability is recommended after 1 year.
Reassessment.
Yes.
Because if it becomes good or bad,
Yes.
it will be known after
1 year,
year.
Lordship.
But where does it say that it is a permanent disability?
Lordship.
Oh, madam, you show me, you be prepared with your cross-examination. You have the certificate with you, copy of this certificate.
No, Your Lordship.
It is there. It must be there.
Yes, the disability I have.
The certificate is there. What is the last column? Tell me the last column. On the table, what is the last column? Disability, then affected parts of the body, then diagnosis. The table,
Yes,
what is the table head?
permanent physical
Table heads are disability, affected parts of body, diagnosis, and permanent physical impairment or disability.
Disability, it's 65%.
The certificate says it's permanent physical impairment. Did you put any cross on this? Have you asked anything in your cross-examination that this disability is not permanent, it's a temporary disability, the certificate is wrong, it has not been well assessed? Anything?
My lord, I was not in the.
When I say you, see, when I say you, I say about the company, the insurance company.
Yes.
When you say Gauhati High Court, do you mean me or the other brother judges? No. You mean the High Court.
Yes.
So when I say you, I will. Your argument is good enough that it had to be reassessed after 1 year. But then it can also be like he has argued that maybe it has increased, we don't know. But The certificate says it is permanent physical impairment or disability is assessed at 65 now. It does not say disability assessed at 65 in the present. So, now in your arguments, if we go by this judgment of the Supreme Court, he is not entitled to that first part.
Yes, Your Lordship.
He is not entitled to how much?
Only for the medical expenses. and-
16 lakhs 84,000 goes.
Mhm.
Yes, sir. Anywhere you have stated that your injury is permanent.
Lordship.
In your statement, where?
Lordship.
Where? Show me. In your statement, in your this thing, evidence. Where did you say that this is permanent? This is a permanent injury. Unless you show me. Where is the cross-examination? Did you cross? Any cross-examination? Must have been.
Lordship, I had prepared one gist. May I forward on?
No, you show me from the
Yeah,
records.
Lordship.
Gist I will see later on. I just want to. The only issue is whether it is permanent or not. What is your name? PW1. Who is it? Sanjeev. I deny the suggestion that I have not involved in the accident. I deny the suggestion that I have not sustained previous injury. The fact remains that under order of this tribunal, I was re-examined the medical board who, after thorough investigation, categorized my injury as 65% in nature. The driver of the vehicle is charged serious considered by the council for the OP number 3 and 4. What did they say? Yes. In fact, what was not there in his evidence, your counsel has confirmed it in the cross-examination. See,
Yes, Your Lordship.
the cross-examination says, the fact remains that under order of this tribunal, I was re-examined by medical board, who after thorough investigation, categorized my injury at 65% permanent in nature. In your cross he has said, and in the, you have that evidence with you. Do you have a copy of the evidence filed by him?
No, Your Lordship.
In his evidence, he says, after thorough investigation, the medical board ascertained my present disability at 65% in permanent in nature. So just because he was required to be reassessed after a year, you have to give me some law on that. That if the injury, if the certificate says that the injury has to be reassessed after 1 year, then it is not a permanent injury, a permanent disability. Because permanent disability is something like this. There are some disabilities which require constant monitoring. Say if a person is with age, it goes bad and bad. When he's young, he will not suffer much, but as he grows old, it keeps aggravating, or it keeps getting better. So that part, you have to show me some law on that. That if the certificate says it is to be reviewed after 1 year, I have to assume that it is temporary in nature. And what does the judgment, in the judgment, what does she say? The tribunal, what does it say?
Page number 10.
Exhibit P9, na?
P9, Lordship.
Where does the court say that it is a permanent
Lordship,
injury? Somewhere
page
in
10,
some paragraph.
Page 10,
Page 10, what does
last
it say?
para.
What does I have also the counsel and going to deposition. Under order of this tribunal, the injured complainant is re-examined by constituting a medical board of the district hospital who the certificate says 65%, madam. What you want it tomorrow? You want to come try and look some judgment? Otherwise my mind is made up. You want a day's time to find out some judgment? See?
I leave it to your lordship only because I can't find any judgment regarding that. So.
Lordship, my profession is I am a painter by profession.
Yes, you also explained how does the broken nose deter you from painting? How does the nose help in painting? Your nose is broken as per the certificate.
Not only
what
nose,
is the
lordship.
disability?
No,
sir?
not
Let
only
us
nose,
see.
lordship.
Again, let us see what is
No,
the disability.
not only nose, lordship.
What?
Yes. Deposition in affidavit.
Huh? Are you sure?
By deposition in affidavit.
Orbital roof.
By deposition in affidavit, page number 2,
This thing got
lordship.
broken. Is it?
My injuries are, lordship, fracture with left frontal contusion, fracture right orbital roof,
yes,
multiple soft tissue injuries,
okay,
displaced fracture at anterior wall of left maxillary antrum, displaced fracture at bilateral nasal bones, dislocation of hip joint, displaced fracture in left bisofrontal bone with fracture line extending to involving left frontal sinus, blunt injury all over the body.
The lesser said about this disability certificate, I am sorry to say it is better. This certificate, it says, if you read the last 3 lines, where photograph is attached below and satisfied that, you find that line? This is to certify that so-and-so carefully examines so-and-so, date of birth so-and-so, being registration number so-and-so, permanent resident of house number so-and-so, where a photograph is attached below, you find that? And satisfied that he is a case of, read that word, he is a case of what?
He is a case of visual disability.
Visual disability.
Lordship.
Where is the doctor? Where is the ophthalmologist?
No, not only, but in the certificate, everything has been mentioned, details, Lordship.
These kind of certificates, Supreme
Yes,
Court
Lordship.
has already held.
But that certificate is not in dispute in the court below, Lordship.
That is the only thing
Lordship.
that is going in your favor,
Yeah,
sir.
Lordship.
Otherwise,
The documents mark and execution consent, Lordship.
that is what they never raised an issue, na?
Yes, Lordship.
They did not raise an issue. Otherwise, that is the only thing in your favor, that the certificate says that you have a permanent disability impairment of 65%, and you did not challenge that. That is the issue. You never took this stand. You must have filed your written arguments. What? Did you file written arguments? Did you file any written
No
arguments?
written argument filed in the court below.
No written arguments.
No written argument, Lordship.
The order, this order of the tribunal also does not say that you made any arguments on that line, that it is not a permanent disability.
Lordship, I have page number 10 of the impugned judgment.
Yes, I have seen that.
Last para. May I read it, Lordship? I have also heard the learned counsel and going through the deposition and cross-examination of the claimant as well as PW2, also the documents marked and exhibited in the course of proceedings. Under order of this tribunal, the injured claimant is re-examined by constituting a medical board of the district hospital, who after thorough examination categorize and assess the present disability of injury at 65% permanent in nature. In the whole course of proceedings, no evidence to the contrary could able to produce by the insurer or by the other opposite party to disprove that there is no rash and negligent driving or of the offending vehicle number so and so. The disablement certificate issued by the board is a public document, and as such the medical certificate is no need to be proved by calling the author of the documents. Otherwise also there is no dispute whatsoever of the opposite parties in this regard. The disablement certificate of the injured claimant, which appeared to me medical certificate issued by the medical board, marked and executed on consent.
On consent, that is what you're saying. They may be marked by consent.
Lordship, even the cross-examination also appeared that there is nothing in dispute of the opposite parties in the court below, Lordship.
And your only ground is that the court had to first determine whether there is any permanent disability, and if so, the extent.
Yes, Your
But
Lordship.
the records show that despite him producing some certificate, he was also sent to a board constituted by the court, where they said he is permanently disabled 65%.
One more, my submission, Lordship.
Yes.
This appeal is not maintainable in the eye of law at all.
Why?
Yes, Lordship. To contest the case on merit,
yes,
insurer ought to have obtained permission under section 170 of the Motor Vehicle Act from the tribunal.
They have not.
They have not obtained permission. So in this regard, I would like to refer
That is why I say, sir, you should put down your objections in writing, one short objection. Yes, you give me that citation.
2002 7 SCC, page 456, Lordship.
456 para?
Para 25 and 26.
25, 26. We'll keep it short now. We don't want to sit after lunch. Just 2 minutes more.
Yes. Page 25, para 25 and 26. Lordship.
Okay. And
yes, Lordship. Here in this regard, they have not obtained permission at all in the court below.
there is
So
no.
they have no right to contest the case on merit.
And what about the deposit of some amount in the contest?
Yes, Lordship.
You are not required to deposit anything when you file an appeal.
Oh,
50%?
I deposited.
You have
Your
deposited?
Lordship, a statutory deposit.
A statutory deposit, how much? How much have you deposited?
25,000 statutory deposit. Apart from that, 50% of the award amount I've already deposited.
50% of the awarded amount is deposited. Have you withdrawn it or not?
No, Lordship. We have not withdrawn it. We are not aware about this actually.
Oh, I think that is the rule when you file a MSc appeal, that you have to deposit some amount. I don't know whether it is 25,000 maximum or.
It's deposited on
25,000
31,
is the statutory
2024.
amount.
Sorry?
31, 2024.
31. See, it is lying there without interest. They have made a deposit, you don't get interest on that. How much did you deposit? Statutory deposit on 31/12/2020?
2024.
2024. How much? No, not there. Okay. Okay, we'll look into it. Okay, we are disposing this off also. You'll have your orders by tomorrow. Should this is disposed of, I'll dictate the order today itself. Okay.
Lots.
So thank you. And we are off for the day.
Pleasure.
Thank you.